Hello and welcome to Evolve Rwanda, yet another exciting episode. I'm sure it's going to be exciting to you. I'm happy about it because in our day-to-day living, there are certain laws that we all need to be aware of, and we do not know about them until something happens to us and you go crying foul. You wish you would be forgiven because you did not know about that law or the magnitude of what you did. So today I've invited an advocate, Innocent Muramira. We will talk about, you and I are laymen, we will be asking to be educated about law or the aspects of our country's laws that we need to be fully aware of. Murakaze neza. Innocent, it's a pleasure seeing you.
Thank you, Jackie.
How have you been?
Good.
Great.
Good.
Thank you so much for making time to join us. In our interactions, Innocent, you often say ignorance
Of law.
Pardon?
Ignorance of law has no defense.
Ignorance of law has no defense.
Yes.
2 weeks ago, I met he's a taxi guy, a cab guy.
Okay.
So he gave me a ride in his cab, and he was a very angry man. Angry because he thinks the marital, you will give me the correct term, the marital laws in this land favor women more than men. And he kept wishing he knew better what he knows today, because when he was he was coming out of a divorce. Yeah, he's a young man, 37 years old, with 2 children, but now divorced from the wife. And he felt like he had been treated unfairly. We talked a lot. And the one thing he said is, he wished somebody had educated him. In fact, he challenged me as a media personality to make sure we have this conversation. Hence the reason I invited you today, because I feel like there are certain laws we all need to be aware of. Even if it's not the entire law, but there should be certain aspects of laws that affect every one of us that we should be aware of. As someone in that field, as an advocate, do you agree with me on that?
Yeah, sure. Like as they say, and it is always said, ignorance of law is not a defense. Ignorance of law is not an excuse.
It's not an excuse.
And for a layman, it is really hard to be always on the right side of the law. And usually when the law is on your side, you can punch your chest. But the moment it turns the back on you, be like, I wish I had known. But there are always repercussions which normally come after the law, or you are against the law, or when the law turns the back against you.
When you're the one in the wrong.
So you find that, hey, I wish I knew.
I wish I knew.
This is a small thing. I wish I knew. Before we dive into the thing,
yes.
I would give you a little hint. You find Jack is signing a contract with Innocent. Verbally, beyond 1 million plus. Like, yeah, I trust you. You are my boy. You are my friend.
Yeah.
Tomorrow, when you are appearing before the judge and you don't have the chance of justifying that there was a contract A, that's when you will know that law can take the day.
That's why you'll know you cannot explain this friendship in court.
Sure, because court is all about evidence. Emotions do not carry the day. The law carries the day. So hence, ignorance of law has no defense.
Yeah.
Still, we will find that in some cases, there is what we call limitation period. You are having a case and you feel like, this case I have merits and I have everything. But are you within the right procedure? So, once we say ignorance of law has no defense, of course, the laws are made by parliament after the consultation with the public and the like. However,
and laws keep changing,
yes,
they're not
change.
static.
See,
yeah.
There is a principle that say law is made out of space and time. Today, in the near future, we are likely to get the law regulating YouTube.
Okay. This channel that we are currently on.
We never had laws regarding cyber harassment because there was no internet. How could one harass you? One could throw you a jab and be like, okay, but today someone can go online and troll you. But
And then I can report them based on the
because even you have evidence,
cybercrime law.
according to the Rwandan law of 2016 on electronic evidence, even a small WhatsApp message, even the emoji.
Even that can be admitted in court.
Because an emoji won't come when there was nothing like a conversation.
Even an emoji.
Yes, you know, Jackie, we are talking about emojis, but how do emojis come in the conversation? We had a conversation and it reached somewhere. We are off the line, and then someone is like, I wish ABCD. He or she brings something which may be injuring your reputation, or someone is abusing you on your phone, in your inbox. Okay, let's take it like this. You're trying to advance your interest in Jackie. Jackie has rejected your offer. Then you continue going into her inbox and you write all the sense and no sense you want. It is not only bothering her, but you are infringing on her rights. Because she has exclusive right on her phone, and it is her liberty. You are infringing on her privacy. So if such a person takes you to RIB or any other institution, then you won't say that you didn't know that writing such a message unoffensive or sending such a sign which is interpreted to mean another awful thing was legitimate, and your ignorance won't apply. You remember.
And so you're saying that, actually, sorry to cut you short. So you're saying it will be within my right for me to present that as evidence. If I go to RIB to report you for harassing me on my phone, that will be considered as evidence?
Friend, as yesterday, you would have brought it.
Oh, okay.
Because, like as I stated earlier, there are laws in Rwanda which allowed electronic evidence to be used in court. Since, according to the law of 2016, it allows any electronic evidence to be presented in court. It can be a recording, those are recording, the short ones we do.
The voice notes.
Those, my friend, those voice notes. Then the short.
We should be very careful what voice note you're sending out there.
It would be better. I'm not telling you to do it. Call someone and tell whatever you want to say, but make sure you are not recorded. Because if you're being recorded, by the way, we still have an issue. Like, this is my opinion. You see, proving a recording is different from proving a message which has been sent from Jackie to me. Because if you export it, it will show you the second when it came. But when you're exporting, sometimes the recording may not come. So I'm not saying that people should use it like that. But you know that you may do it today. You escape. But if you do it to Innocent or to Jackie who knows the law, he or she may pin you. And the consequences may be bitter. Because we all know that not knowing the law does not make you innocent. And even crying before the judge or before RIB, it won't help you. Because there is a presumption that once the law has been passed, it is gazetted. Once the law has been gazetted, the presumption is that every Muturaji knows the law. However, we should say, do all people get access to those laws?
Yeah.
Now, it is the responsibility of the state and the government to encourage people, to sensitize people about the new laws. I think 2 weeks back, the Minister of Justice has started publishing laws on Twitter. They are posting those laws on Twitter. They are saying this new law is out, Company Law 2021 is there, the law on ABCD, they are there. Say that because today, Jackie and I and the rest, we are spending much of our time on social media. You find that Jackie to go to a certain library in a place X, it may not be easier for her, but on her phone, it is easy. So it is one way of making the public to get into the know with the laws.
So that we have no excuse.
Yes, at least, because you find that most of these offenses, like I remember, was it last year, some sisters of ours danced in front of their live camera.
Oh, yes, on Instagram.
When they were taken behind those institutions, they said, no, man, me, I didn't know even dancing in front of my phone is a crime. But there is an article 38 of that law on cybercrimes, talks about publishing indecent.
And so you'd say there are several cases that have been taken to court?
Of course. It depends on the prosecutor. Once such, you see Rwanda, and we normally say this, Rwandan justice system, they follow up the cases.
No doubt.
They follow up the cases. It's not that Jack is going to come with influence and be like, that case is dropped. No.
They follow it.
Unless there is no prima facie evidence. Prima facie evidence, we mean evidence which is convincing. Because, you know, if I've been taken to RIB or to any police station, I'm a suspect. When you go to the prosecution, you become accused. Do you know how? Why? Have you ever asked yourself?
Never.
Those 5 days you spend at RIB, there is investigation going on. You are still a suspect.
And I should be at RIB. I cannot
Someone has
go
filed
home.
an allegation against you. So during those 5 days, RIB is making investigation. Is it true that Innocent really forged his certificate? Now, once there is evidence, they will push the case to. There are cases which end at RIB, by the way.
Okay.
Once there is some convincing evidence, the matter goes to prosecution. Now the prosecutor represents the state because there is already a case now there. He or she the one who will go to court. Which is slightly different, totally different from civil cases. Civil cases, it is Innocent versus Jackie. Criminal cases, it is the prosecutor versus Innocent. Because the crime committed, it is not only committed against Jackie, but to the whole community.
That's civil. No,
That is criminal.
That's criminal.
Criminal now. Which is different from where you gave me 1 million and I'm like, I'm not going to pay you.
That is civil.
Yes, that is civil. Because it is between us. And under the laws of Rwanda, specifically Article 29, with the Constitution, provides that you cannot be taken to the prison for not complying or fulfilling a contractual obligation. If you refuse to pay me that 1 million, or if I refuse to pay rent.
Yeah, you see now that you've brought in a contractual obligation,
yes.
let us move into another area.
Now.
We've talked about cyber crime. Let us talk about contracts. Should they be written? Should they be verbal? What is considered?
Let me show you. Let's take it on the ground level. Where you are tenant, you are the landlord, right? We enter into a contract.
Verbal in most cases.
Verbally. Yeah, Innocent, I know you. You are a lawyer. You won't fail to pay my rent. Tomorrow I may wake up and say, no, that house was not for 150. It was 100. And then, now we will be proving who is having superiority. No, my house was for this. Do you know why we are arguing? If we had black ink on a white paper, we would not be arguing about that.
We'll just produce the evidence.
It would be like, hey, look at this. However, it does not go off like that. Even another contract can be proven with conduct. If you're paying a rent, these days we use bank account, we deposit money on the bank account. We deposit money on mobile money, something like that. So it is easier with the proving another contract. You can prove it by conduct and by performance. You told me to supply beverages. I have supplied, you know. Let's say within such stuff, of course I wouldn't encourage people to go in oral contracts, but at least have something to build on your case. You don't have the real thing, however you have like
an SMS,
yeah,
or a transaction.
Jackie, when am I getting my money? Have you received the thing? How is it? Try to build that conversation such that it will help you somehow. I normally tell my clients when they don't have a contract, I will tell them, you know what? Bring this money, we write a demand notice. There is no reasonable person who wakes up and sends you a demand notice if there is nothing. So
then let me ask you, Innocent, are you telling, because by the time you're telling them to allow you to write a demand notice, then maybe from the onset people do not know the importance of contracts and which forms of contracts are admissible. So are you going to tell the person that is watching now what to consider whenever they're entering into a relationship with someone or whatever business relationship or whichever? Are you going to tell them what to be very keen about?
Literally, the law of contract, specifically 2011, it provides that both oral and written contracts are legally acceptable.
Okay.
However, proving the oral the oral one
becomes a
may
problem.
be disastrous and hazardous. Because even the courts we normally run to, authorities we normally run to, you have to come with evidence.
Okay, so that's why you're saying, in the, because you didn't have a written contract, you had a verbal one, but you have messages
Right,
showing
yes,
that
right.
you send money.
And,
If I gave you a job, there was a place where I asked you why you haven't reported for work, or I've sent you to
Yes.
Musanze on an assignment,
And
you
another
can use
thing
that.
we would say in equity, he who seeks equity must come with clean hands.
What does that mean?
If you are coming to claim some money or something related to that, show that at least you have tried. And again, equity helps the vigilant, not the indolent. If you're sleeping on your rights, yet knowing that they are rights, there is something you ought to have done, then you won't get equity. Those are the principles in law on equity. If you're seeking equity, you must have clean hands. Let's say, Jack, you're saying Innocent has never done ABC, and you're the one complaining. But you also know within your heart, you know something dark there, and you're seeking justice. Are you coming with clean hands? Then, if, like as we said, having a contract, knowing that employment contract above 1 year must be written, and then you, Innocent, you have worked, of course, you will say undue influence from your bosses. The boss is not giving the contract. But what happens to the employer? The employer who has refused to give contract and it has been sued. Shall we say he was vigilant? Then
By refusing
equity
to pay, no.
helps the vigilant, not the indolent.
Okay, okay.
Now, one would mean that any contract for the sale of a car, a house, must be written. Any, I would address my mind on that. Any contract above 50,000 Rwandan francs must be written. I would address my mind on that.
Yes.
Specifically the articles.
Okay.
Any contract of employment above 1 year must be written.
Written and signed by both parties.
Absolutely. Absolutely. But you know, when we go to employment contracts, we also have issues. Employees and employers.
Yeah.
The employee will come looking at salary, period, probation, gone. You don't go behind to see what are other prohibitions one is not supposed to do. So you find an employer like Jackie, they have internal rules and regulations for you just to get your black blue pen and you sign. You don't actually know what you're doing. You don't actually know. You haven't read the contract. You haven't read the employee manual. Tomorrow when they say, Innocent, you have come late, our employee policy says you will be fired, you'll be like, no, I have a lawyer there.
So you advise us to read that contract.
Even your lawyer won't help you.
Because after all, you signed it yourself.
Because you have signed the other principle now.
Yeah.
You remember?
Of not being forced to sign.
Yes.
You signed it on your own. Let's come back to that.
Yes.